make a difference to you, acknowledging there's an adversarial system, if you knew that your opponent was already aware of those issues and was busy raising them in written form and attempting to have them litigated? Wouldn't that pretty much resolve your ethical issue by you seeing that it's already been identified and is being addressed?
Yes. And that's where most of my shortcomings and errors have been revealed. When the other side says, hang on a minute, that model's wrong.
Right, and that's part of the adversarial process when it's working best with good lawyers on both sides, and as you suggested before, two experts who are sort of testing each other's work. And even under the best of those systems, we may come to the conclusion of a case with two different opinions, can't we?
Yes.
And I guess I want to come back over that. You know, some of these forensic fields that we deal with, like the ones perhaps that Dr. Kerrigan is in, if somebody brings in a vial of blood and they want to know what the blood alcohol level of the person is, if 10 scientists test it using the same instrumentation, assuming there's enough there to do it, they should all mathematically come up with the same numbers within a certain range, shouldn't they?
If they are competently carrying out a reliable and analytical method, yes, they should.
Right. So for 10 people testing that blood, let's say it comes back 0.25, all 10 of them are going to scientifically, mathematically, and consistently say that that person was intoxicated under the laws of Texas, right? That's a very likely scenario, assuming they're all doing their jobs correctly.
Yes.
But in some other fields, where there is more room for subjective interpretation of facts and the application of judgment, as Dr. Wiley was helping us understand, you could bring 10 scientists into the room, give them the same set of facts, and you won't all come out with the same answer, will you?
That's correct. You mean in terms of fire investigations?
That's
Yes.
where I was going next.
Yes.
And isn't it fair to say that fire investigation, even as 921 is today, there is a lot of judgment making going on with the individual parts of that, aren't there?
Yes. The issue is, what's the quality of the information on which that judgment is being made?
That's right. And two good fire scientists and fire investigators looking at the same set of facts can both be competent, can both be appropriately trained, and still come to two different conclusions, hypothetically.
That's true.
So when we talk about the differences of opinion and people being right and wrong, would you agree that there is more room for interpretation in fire science than it is, for example, in toxicology?
Yes.
Thanks.
Dr. DeHaan, you mentioned earlier that one of the things that troubled you about the investigation, trying to look at it in the state of such investigations back in 1991, was an apparent failure to sift through any debris, push it all out, and not obtain it. Tell me if there is anything else, or in your review of all the materials, everything you know about this case, are there any other things about the investigation that, in light of what was going on back in 1991, also give you trouble or give you pause?
Well, probably the failure to look at the laboratory results and compare it to the original hypothesis was troubling. I mentioned that earlier, is that the hypothesis was that a great deal of ignitable liquid of some sort had been placed in the structure to accomplish the patterns that were observed, and none of the tests were positive except for one at the threshold, which had questionable value. And there didn't seem to be any comparison of those contradictions.
Can I interrupt you?
Sure.
A follow-up question on that? I
Sure.
don't want to lose the train of thought, but it is stated earlier, Dr. Fowler, that it's a possibility, it's possible for all the accelerant in a particular fire to burn up. when you were talking, based on your experience, when you're talking about the apparent amount of accelerant that Investigator Vasquez described in the trial testimony, how likely is that it would have all been consumed in that bedroom based on his theory of the fire?
That the amount is one consideration. Another one is the duration of the fire, and how much of the structure survived. Those all play a role. And judging from the photographs that I saw, there should have been enough absorbent material in the walls and the wall framing and things like that, that if there were a lot of ignitable liquids poured, that some of it should have survived, yes.
But the fact that it didn't doesn't mean you're concluding that there wasn't flammable accelerant. I mean, we're kind of going back to, Dr. Byler wasn't going to jump on that because it's, you got to be certain, you got to be sure. It's not about maybes and possibilities, is it?
Well, if you don't have positive physical proof of its presence, you shouldn't be concluding that it was there.
Or concluding that it couldn't have been there.
Well, in this case, could that fire have been started intentionally without ignitable liquids? Yes.
And it also could have been started intentionally with ignitable liquids. You haven't ruled that out, have you?
That's correct.
Okay.
You had given an opinion to our chairperson here that in arson you can have different opinions, but not in toxicology. I just want to go. I want to
I
explore.
was leaving them to go.
Explore this a little bit more. I mean, the question that he asked was that if you analyze something in the lab, shouldn't 10 different labs have the same result or about the same result? The answer is yes.
Yes.
If the labs are good and the specimen is preserved properly and the good techniques were used and good standards were used, so I expect that. And I expect the same thing in arson laboratory investigation. If you do analysis, the analysis should all come back the same. But the opinions may clearly vary. I mean, if you have a case with fentanyl overdose, and correct me, Dr. Kerrigan, that's all to tell you 3 to 5 nanograms is the lethal level. But I have called it an accidental death, in lower levels, and I've called it an actual death with higher levels. So opinions vary depending upon a given case. So in the arson investigation, your observations of the scene are interpretation of what you see. In that you can vary in your opinions, but not in the hard science, which is analysis. Am I correct?
That's correct.
Yeah, so I mean the answer was that no, you're comparing apples with oranges.
Well, the issue here is that the final conclusion was not based on analytical science.
Exactly. They were just observations. And we know those were flawed based on current understanding of science.
Yes.
Thank you.
One final follow-up question on that. The answer to the question I asked just a minute ago, they're concerned about not going back and looking at the lab reports and noting the significance of no finding of accelerant. That would be in terms of what was in practice in 1991 or what was in practice today?
No, I would have been in practice in 1991 as well.
Okay. And I interrupted you there. I think you were going to go ahead after that question and maybe list another concern that you had.
Well, it was touched on briefly, and that was along the same lines. There was an implication that the ignitable liquid extended on the front porch, and yet nobody saw any fire on the front porch in the initial stages of the fire, and that was another contradiction. So that should have called the investigators' attention to question that conclusion as to where there was liquid.
We've got about 14 minutes. Dr. DeHaan, anybody else have anything?
I believe there was a letter that the Texas Forensic Science Commission received from the State Fire Marshal's office, I believe, in about August of 2010. Were you provided a copy of that?
Yes, I was.
Okay. And in that letter, I'm paraphrasing, but essentially it was the opinion of the State Fire Marshal that they would stand by the original investigators' conclusions today, not back in 1991, but by today's standards. Was that your understanding of reading the letter?
That was my interpretation, yes.
Do you have any thoughts or opinions about that? What was your sense when you read that?
I was dismayed to see that interpretation, or to reach that interpretation on my part, because the examples, for instance, that were given to support the conclusions and why that logic would still apply today basically took portions of 921 out of context and said, where things said it could be, and the clear interpretation of that the investigator gave during the trial was, it was this. And 921 clearly says it could be. We talked about alternate explanations, and if you only pick one just to support that, the one of multiple indicators, but the most biased one in terms of a conclusion, then that's not appropriate. And some of the points that were raised weren't on point in terms of ignitable liquids and sealing pattern damage and things like that. So yes, it was dismaying to see that all we've tried to do in the intervening 13 years didn't seem to have made much difference. Whereas the documents themselves are very different today. And our knowledge base is very different today.
Dr. DeHaan, thank you for coming.
Actually,
Yeah.
I don't.
All right, go ahead.
Did you have any, there's, kind of get into some specifics. I think there was some testimony given about the temperature of wood burning and the threshold and all of that. Let's not talk about today. I think that everyone would agree that under today's standards, that's clearly not going to be reliable in making an arson determination. But do you have any comment on that statement in light of what was known back in 1991? Wood only burning at that temperature and not being able to melt aluminum, for instance?
Yeah, certainly the scientific data back then indicated that temperatures of 800 Fahrenheit or whatever the citation was weren't significant in any way, and that I don't know where in fact that temperature estimate came from, but even back in 1991, the scientists, at least involved, and many of the investigators knew just from the simple thermocouple tests that you could do on a benchtop that the temperatures, the average flame temperatures of ignitable liquids weren't much different than the flame temperatures above a pile of wood sticks. And so it was of no value in evaluating whether a fire was fueled by flammable liquid or not. There was mention of spalling, which is the degradation of the concrete surface, or discoloration, and those were known then not to be reliable.
Back in
pre-1991, yes. There was mention of an aluminum threshold, and I thought at one time that there was an implication that it had melted or softened or distorted, and that was once, certainly in the late 80s, promoted as an indicator of intense high temperature flames at floor level, and therefore would have been produced by ignitable liquids. And I'm not sure where along the line people finally realized that that's not possible. And once again, all it took was a simple benchtop test to show you really can't melt aluminum thresholds with gasoline or kerosene.
Do you recall in the materials that you were given or reviewed talk about auto ventilation and the reliance on that by investigators?
Yes.
Do you have any thoughts or comments on that in light of what was known back in 1991?
Well, certainly by 1991, there was a lot of observational reports of fires involving ordinary combustibles causing windows to fail. The issue of crazing of glass was, of course, still current. In fact, I think even my 1991 textbook mentions crazing, and that's the partial thickness fracturing of glass being an indicator of a very rapidly increasing fire, without indicating that that meant igniting liquids, but implying that it was an unusually fast fire. And it wasn't, I don't think, until later in 1991 that there was a published article actually testing that hypothesis that showed that crazing was caused by water on hot glass, not by thermal shock alone. But certainly anybody who'd ever observed fire tests where the fire got well involved in a room realized that window glass shatters, no matter how the fire started. So that wasn't a reliable indicator even then.
Obviously, we've touched on the fact already that eyewitness testimony needs to be used and needs to be factored in. Now, obviously, we can argue about the degree to which you need to rely on it. Sometimes you've already discussed, I think, that sometimes it's possible to go over the line in relying on that. What about part of a forensic expert students? Eventually, he's going to wind up in the courtroom and testify. In reviewing all this material, do you have a general opinion on whether an expert could be professionally negligent in the methodology of his testimony, or do you not? Do you have any observations on any of that?
No, I couldn't really reach that conclusion because in an adversarial system, you're constrained by, for the most part, what somebody asks you.
Right.
And sometimes that touches on critical issues, and there are times, even as an expert, that you think the court's being kind of misled by the way the questioning is going, and you try to edge the answer the other direction, and you get reprimanded.
I'd be the first to agree with you that attorneys could certainly influence that by the methodology of the question. What about just as a general concept? Now, I'm not talking about with the Willingham investigation or the Willingham investigator. I'm talking about just as a general concept. Is that even possible for someone to be professionally negligent in their testimony?
Oh, yes. Yes, if you misrepresent the evidence, misrepresent your conclusions, or testify to things that you know are untrue, that are not supported by your data, yes.
Do you have any reason to believe that the investigators in this case deliberately misrepresented what they thought?
No, I don't.
Let me ask you just a real quick hypothetical to kind of sum up what I think I'm hearing, and you're going to be able to correct me or correct my misinterpretations. My hypothetical is I set a fire. I admit truthfully that I have set a fire. There's an arson investigator that comes in. There's an arson investigation done. We're trying to use all of the things that we know that are reliable about arson usually. And for whatever reason, there's nothing concrete that can verify my story. Can you have a situation in which I've truthfully admitted that, and yet an arson investigator, following the proper principles, would have to say that the cause of fire is undetermined? I guess my question is, can you separate the two?
No, because good investigative practice always means you evaluate the statements of witnesses and involved persons. And that includes confessions. And if all you have is a confession, you go, well, I don't know. I mean, the example I use when people say, well, this person confessed to this crime and he had to have been responsible, you go, well, there were at least 7 people that confessed to being Jack the Ripper. That means at least 6 of them were wrong. And so, what value did their confessions have?
When I tell you I did it, of course, you're going to take that information into account and use it when you evaluate your findings.
Yes. And so if I find if I find your statement persuasive, but I don't find any other information, when I present that to the prosecutor, the prosecutor's going to look at it and say, what else you got?
I see.
At least that would be my expectation.
But you're not here representing that fire investigators or fire scientists such as yourself are experts on the credibility of confessions. You don't have any special training or skill that allows you to watch or listen to a confession and come to a conclusion any better than anybody else, whether that's a truthful confession or not, do you?
That's correct. That's the realm of the police investigator.
Or some other decision maker.
Yes, in some cases, yes.
So in the hypothetical that Lance has given you, the differences of opinion about whether someone was responsible for Lance's arson might be completely independent of the fire investigation and come down to people's differences of opinion about a confession.
Yes, it could.
And both sides can make reasonable arguments, and it may ultimately be resolved by whatever decision maker is supposed to make a decision about those things.
Yes.
That's not negligent, is it?
No.
I want to explore this a little bit more though. As a scientist, would it not be your duty to say that I have no proof to say that this is an arson or not? And then put a comment saying that I cannot judge whether this testimony or confession is true or not, but I can say that I have no evidence to say this is arson. Wouldn't you say that?
That would be my critical role.
Yes.
Yes.
You would not just say that just because somebody said it's an arson, it's going to be an arson.
Right. That would be my critical role as a forensic scientist, to say, well, taking that as one point of evidence, do I have anything else to support it? If I don't, then I'm obligated to say, I don't have anything else to support this.
So would you be then undetermined still, or would you call it an arson off the confession?
Isn't that a maybe answer?
I know how I would do it. I would want it undetermined.
Exactly.
Yes, so if I were the investigator there,
Really?
I
So
would.
you've never had an autopsy in which the cause of death could be undetermined or homicide, and you get a confession and you judge it to be credible and you decide that it's a homicide? You've never done that?
I have rarely done that.
I didn't say rarely. It happens, doesn't it?
It depends on a given case. But
Sure it does.
I would say that in the vast majority of the cases, I would put a comment. I get from time to time reports of mothers saying that I smothered my child. Just because the mother said that doesn't mean it is smothering. I have no evidence. I would put it undetermined and put a comment. The confession says I smothered the child. Leave that to you to decide with the grand jury and the courts.
But you would certainly have had cases where the confession or some eyewitness statement was a critical factor in helping you determine, independent of forensic science, that it was a homicide. You've done that.
I would notice I haven't done it because I can't record a single case. But that doesn't mean I didn't do it. And if I did it in the past, I assure you that I'll be very cautious in the future.
Well, I think my point is that's not an unprofessional thing to do, is it?
To do which?
To use this information to assist you in drawing your conclusion.
Well, it depends on my role. If I'm a forensic scientist looking for physical evidence, and I say there's no physical evidence, then it's going to be up to somebody else, as you just pointed out. I don't have the training or experience to evaluate somebody's statement. And so it's going to be somebody else's decision.
But your book and 921 doesn't say what you just said. It says you can consider those statements in helping you form that conclusion, doesn't it?
Yes. And so if that's all that suggests or supports the hypothesis that this was a deliberate fire, that's going to come out as an undetermined fire.
Thanks, I appreciate that. But that doesn't mean somebody else can't conclude this arson based upon the other information.
I'd have to ask them why.
Well, I'm sure you would, but that scientifically, you're just answering as to the physical evidence.
That's correct.
You're not issuing an answer as to the credibility of the eyewitness statements or the confession. Somebody else is going to do that, aren't they?
That's correct. It's supposed to be the trier of fact.
That's why I'm asking you, because in our profession, in forensic apology, we rely a lot on the arson investigation. And that's why I'm asking, if you have someone who just totally confessed, you believe the confession, you have suspicious areas, you are suspicious your accelerants are negative, but someone's confessing to it, could the arson report then, or could the report then say that it was deliberately set based on that statement, and put in a conclusion that, we couldn't